Good morning, everybody. You're very welcome to the Myerson Solicitors webinar today, the 23rd of April 2020. You will notice when you've joined today's webinar that your microphones have been placed on mute. Can I ask that you switch off your video cameras and keep your microphones on mute throughout the duration of today's talk? If you look at the bottom of your Teams panel, you should see a menu which has got 3 dots in it. To the right of it, there will be a speech bubble. That's your chat function. I'll be inviting people to submit any questions that they have through the chat function, and we'll pick them up at the end of the talk. Today's talk is one number of talks that Myerson Solicitors have been running over this past number of weeks as a result of the issues arising from COVID-19. And the idea is to assist you as best you can through these difficult times. I'm the partner and the head of the Real Estate Litigation Department at Myerson Solicitors. And whilst the talk is going to cover a number of property-related matters, the principles apply more widely. So let's deal with our agenda for this morning. So the first thing we're going to look at is what is an electronic signature. We're going to look at what then is a wet ink signature. We'll move to deal with contracts and deeds, and then witnesses attesting the signature in a deed, and then we'll pick off statutory declarations, affidavits, and administering those before we move to questions and answers session at the end. So I'll begin by looking at what an electronic signature is. Well, the electronic signature is something that's been around for quite a while. In September of 2019, the Law Commission report titled Electronic Execution of Documents had sought to recognise the use of electronic signatures across the board, having consulted with various stakeholders. And the government, in very hushed and rushed form in March of this year, adopted what the Law Commission's recommendations were. And effectively, an electronic signature is something that we probably have used at some point in time when we have maybe accepted a courier's delivery, where we've placed our finger on a stylus or used a stylus or signed something that the courier has given to us. That's just one example of it. Another example of the electronic signature is copying, pasting an image of your signature into a document, or even typing your name at the bottom of the document. And more recently, people are using electronic signature platforms, and Adobe have an example of that. These are more secure, and those are just one of the number of ways in which you can use an electronic signature. So when I talk about electronic signatures and signatures generally, you can say that a signature includes an electronic signature. When we talk about using of electronic signatures in documents, there's one important point that we need to always bear in mind, which is that if we're going to be using a signature electronic form for a company, the company's articles must not prohibit the use of an electronic signature. And that's really important. So if your company has articles, check them. If you're going to be excluded from using an electronic signature, then the company needs to be aware of that. And any of the officers who are going to be executing any documents or signing any documents need to be aware of the prohibition. The second thing that I want to mention in relation to electronic signatures, which is often overlooked, is if there are multi-jurisdictional considerations applying to your contract, then you need to bear in mind that not every jurisdiction will recognize an electronic signature. It's okay if your contract expressly provides that the laws of England and Wales will apply, but if actually jurisdictional elements of your contract are such that that isn't true, then you need to check with the local law that is applicable to your counterparty in relation to whether or not they can use electronic signatures to sign their documents. So let's move on now to what most of us will recognize as a conventional signature. It's known as a wet ink signature to distinguish from an electronic signature. And what I want to point out is that in this talk, we will not be looking at wills, and we will not be looking at lasting powers of attorney. Those are not covered in this talk, and they will be covered in a separate talk by one of my colleagues who will be giving the seminar again by web link today at 2 o'clock. And for those who want to join that, you can look out for the link to that in the chat functions, or alternatively, you can download the video and watch it at your leisure after this afternoon. One of the other points that I want to mention is that when it comes to registrable dispositions under the Land Registration Act of 2002, they absolutely mandate and require and will not accept anything other than a wet ink signature. So if you're dealing with dispositions which have to be registered with the Land Registry, you must have a wet ink signature. In the Electronic Execution of Documents Law Commission report, the Land Registry had been consulted on this point and were very forthright that electronic signatures were not acceptable in relation to dispositions that were to be registered. There is one exception to this, and that is digital mortgages. So for every other disposition which is to be registered, you need to have your wet ink signature. So that deals with electronic signatures and wet ink signatures as concepts, and we're going to see how they now apply. So we're going to look at the first thing, which is contract. Now, some people may have seen in documents where people have to affix a signature by deed or underhand, and underhand is simply just contract, simple contract. We'll come to deed next, but we'll deal with contract first. Now, I want to unpack the issue of contracts into two categories. The first one is where there is no requirement for a deed and there is no requirement for there to be a wet ink signature. Now, I've put on screen a list of examples which you may come across in practice. So if your contract says that it requires you to have a wet ink signature or to be executed by deed, then you can't do it by contract and you can't do it by electronic signatures. That's the first thing to look out for. But the other examples are where you have a license to occupy, where there is a lease for less than 3 years, and where that lease does not contain a registrable disposition such as an easement. So bear that little tripwire in mind, that if you have a lease, no matter for how short, if there's a registrable disposition within it, such as the grant of a lease, then it must be by wet ink signature. Landlords' consents which are not mandated in a lease, for example, to be given by deed. So if it is simply a case that landlord's consent must be obtained in writing, then you can have an electronic signature and you can also have it by simple contract. And then also you've got contracts for sales and purchases, which is what we often see and encounter on a regular basis. The second category is where there is no requirement for a deed, but there is a requirement for a wet ink signature. And the example that I'll give on the screen there is UK tax filing, albeit the revenue have temporarily said they will accept for a short period of time electronic signatures. You also have transfer of intellectual property rights, stock transfers, and agreements which require variations to be in writing and signed underhand. So those are the examples where you'll have to have a wet ink signature. Now we'll move to talk to deeds. Now, it's important that we again unpack this. So you've got a deed where there's no requirement for a wet ink signature and where there is a requirement for a wet ink signature. And again, you'll see the examples on screen. So if you have to enter into a deed, and I say have to rather than choose to, then if you're entering into a simple deed, there is no requirement for the deed to have a wet ink signature. A lot of people will assume that a deed has to have a wet ink signature, but that is not correct. You also have no requirement for a wet ink signature in a deed where there is a lease for less than 7 years. And again, if there's a registrable disposition in it, such as an easement, then you must have by wet ink signature. That's the tripwire that I talked about earlier. And then landlord's consents, where the deed is mandated to be obtained. So you may have a situation where you're not to assign or carry out alterations without the landlord's consent in writing by deed. And there you'll have to have the deed rather than the simple contract we talked about earlier. The second unpacked point, which was where there's a requirement for the deed, but to have a wet ink signature. And this is the one where everybody defaults to because they think a deed must be in a wet ink signature form, but it's only in certain circumstances that we require that. And that's where there's a lease for more than 7 years, a lease for less than 7 years, but where there's the lease contains that registrable disposition, such as the easement we talked about. Charges, that's an important one, charges by way of legal mortgage, and then other dispositions which require some registration at the land registry. And there's those are just examples. So when deeds are being entered into, they must have the person making the deed witnessed, or as we refer to, attested. Now, there's a number of ways that you can do this. And in the current climate where social distancing and people may not be readily available to come and witness deeds, the first question I would ask is, do we need to have it done by deed? Because if we don't need it by deed, then we can do it by contract. There's no need to have anybody attesting the signatures. But if we do have to do it by deed, there's another way around having it to be witnessed. So the first thing is, if a company is executing the deed, as opposed to an individual executing a deed, we look at it in a different way than if it was an individual. So let's look at the companies first. So companies can sign a deed by one of its directors in the presence of a witness. And I want to labor the point here is that there is absolutely no requirement for that witness to be independent. It's just so long as they're not a party to the deed. So if it's a case that in a household, a husband and a wife, and one of them is a party to the deed and the other is not, then the other spouse can witness the signature of the other. Now, there may be ways around having to have anybody witness the deed. And the way you can do that is if your articles allow it or your resolutions are passed, you can have one director and one secretary, or you can have two directors sign the deed and there's no need for it to be witnessed. And just so that you're aware, again, these things can be done sequentially. It's not the case that the directors have to do it at the same time or the director and the secretary has to do it at the same time. So let's move to look to individuals. Individuals are slightly different than companies because the deeds themselves have to be attested by the witness who is physically present. And this is causing a problem because the physical presence of the witness is there and it cannot be moved at the moment. We're waiting for guidance to come out as to whether or not there's going to be any departure from the requirements for those attesting signatures and deeds to be allowed to do it remotely. And at present, the answer is no. You cannot witness a deed remotely. You must be physically present. But again, we're back to the scenario where that person who's attesting it or witnessing the signature doesn't have to be independent. One of the points that I want to labor in this is that there are a number of articles that are out there which are suggesting that people can attest these deeds by video link. That is wrong, and the deeds will be void if there is a challenge. Unless a wet ink signature is expressly required in relation to the deed for the reasons we talked about earlier, then electronic signatures will be perfectly fine. And that applies to both those who are signing the deed and those who are attesting it. Statutory declarations and affidavits. I'll refer to statutory declarations because the principles in relation to administering statutory declarations and affidavits are the same. And it's customary that the person who's making the declaration and the solicitor who's administering that statutory declaration are physically present in the same room. And that's custom. There's no statutory requirement for it. But over the past 120 years since the legislation came in, that is how it has been adopted. There's no current case law which suggests that we can depart from that. And there is no guidance yet circulated which tells us we can depart from that. The Law Society took down from its website guidance last month in relation to whether or not those who administer the statute declarations and affidavits could do it remotely. And we're waiting for them to finalise and put back on the website the guidance on that. And I checked just before we started this conference this morning as to whether that guidance had been updated, and it hasn't. There still is no guidance on the Law Society's website. It's not necessary for the solicitor administering the statutory declaration or affidavit to actually witness the person who is signing it physically. So as long as the person who has presented it for the administering of the statutory declaration, the solicitor can administer it. They don't have to see them physically sign it. Also, a solicitor with their client's authority can attend another solicitor and ask them to administer the statutory declaration. So it's not a strict requirement the person who is making the statutory declaration has to be the one in attendance. Now that takes us to the end of the webinar talk this morning. I appreciate that there's a huge amount of information that I've just given to you, and that I've tried to compartmentalize it into a number of categories. One of them is electronic signatures, which can be used unless a wet ink signature is required. And there are certain exceptions as to when wet ink signatures are required. We've also looked at contracts and deeds, and whether or not actually you need a deed in the circumstances. And also, when it comes to deeds, the issues in terms of witnessing it and how we distinguish between companies and individuals. And finally, we've looked at statutory declarations and affidavits and administering. Now, if you wish to ask any questions, by all means do. As I say, there's a speech bubble to the right of your three-dot menu at the bottom of your Teams screen. If you could populate your questions in that chat function, I'll go through them now and address them as best that I can. If you can't think of any questions now, or you want to raise anything separately, by all means, you've got my contact details on screen, and please reach out to me if you think that you've got a question to ask. So let me have a look to see if there are any questions that have been populated. Just bear with me. So we have a question here, which is from Louise. It says, what is the difference between a deed and a contract? Yes, that's a brilliant question. So a straightforward contract is what most people will enter into on a regular basis, day in, day out. And what typically happens is the parties to it agree the terms, and they will pay sum of money over in exchange for a good or service. That's the typical simple contract, and it can be done in writing or it can be done orally. And the flow from one party to the other is the supply of money in exchange for good or service. That's what we call in the trade consideration. Now, deeds are different in the sense that no consideration is actually required in respect of either party. So that's one of the things you can get around. The second one is that under a contract, a breach of it, typically breach of contract claim has a statutory limitation, which is 6 years. There are certain exemptions to that in relation to knowledge, but we won't go into it in today's talk. But indeed, the limitation is longer. It's 12 years. So there are maybe certain circumstances where you will actually want to have a longer limitation window, and you will execute your document by deed. So those are the two main examples of it. One of the issues that you need to bear in mind is the witnessing, and we talked about the witnessing of the deed. And if you think about an individual entering into a contract, they don't have to have a witness, but entering into a deed, they will have. And there are the certain rules in relation to the witnessing of it that we've talked through. And also certain transactions are absolutely required to be done by deed. So for example, if we look at any conveyance of land or dispositions, Section 52 of the Law of Property Act 1925 militates that those are done by deed. There are other certain statutory examples and case law examples where you may be required to execute certain things by deed and not by contract. And indeed, some contracts themselves, we talked about consents from landlords, which militate the consent to be given by deed. So the contract or the deed itself may militate that other documents must be given by deed. So those are the main distinguishing features between it. And that's why I was trying to ensure that when we talked about contracts and deeds, you understood the difference so that you know when you had to have witnesses and when you didn't. So question, can one party use an ordinary signature and the other party use an electronic signature? Okay, so I want to unpack that question. We're working on the basis that electronic signatures can be used, so we don't fall within one of the exceptions we talked about earlier, and B, that they can be used in the sense that there's no prohibitions by the company's articles if it's a company or multi-jurisdictional. So yes, then the answer to that is yes, as long as you have none of those prohibitions, you absolutely can. So let me give you an example. I could, if I wanted to, sign in wet ink and then somebody else sign it in an electronic signature. Indeed, I might have to have my signature witnessed, and the person who's witnessing may elect to go and use an electronic signature. So yes, you can absolutely use electronic signatures. as wet ink signatures. And just to be clear, when there's an electronic signature placed on a document, that electronic signature is treated the exact same if it was a wet ink signature. It's treated as an original. So let's have a look at another one. This comes in from Adam. The form of electronic signatures is irrelevant so long as it relates to the content of the agreement. So more statement on the question. Deborah Ward, litigation undertakes a deed of assignment from proceeds of a client's financial remedy. Could it be, I can't see the rest of your note, could it be classed as a simple deed? A deed of, right, so when you deal with assignments, there's a thing called an equitable assignment and a statutory assignment, and it's covered by 136 of the Law Property Act 1925. So if you're going to do a deed of assignment of a cause of action or some claim, then you would have to do it by deed. There's no such thing as a simple deed. I think you're asking, is it perhaps maybe a contract? If a deed is required for an assignment, then you would absolutely need to have the deed. If it's simply a contract that you can do an assignment for, yes, you can. I'm not sure if that answers your questions, but Deborah, if you want to follow up on that separately, by all means, you've got my contact details on screen there. Jonathan Frank, Seán, I understand that a non-party to a deed can witness, even if it's a family member. I was always under the impression that it should be, I just unclick that so I can see it, should be independent witness and should not be a relative, to make sure that the witness was at arm's length in the event of a future dispute. Yes, right. So the way it works is there's absolutely no requirement for the witness to be independent. Absolutely none. The only thing is that the witness cannot be a party to the deed. Now, best practice is to have a completely independent third party witness the signature, but we're not in the world where we can readily available get access to witnesses. So in the circumstances we find ourselves in, this is to help us through the COVID-19 lockdown at the minute, as to how do we have deeds witnessed. And therefore, if the person that you've got is a member of the family, albeit they're not a member of the party to the deed, yes, you can have them sign it. I know it's not ideal. I know that it's better practice to do it with an independent third-party witness, but we are where we are in terms of COVID-19 and the luxury of being able to go to third parties to have them witness things. A lot of us don't have it. Some may have, but a lot of us don't. Let me see if there are any other questions. I think that's all the questions that have been raised so far. As I say, if you have any questions that you would like to raise, not in the chat function, by all means, contact me. We'll do our best as we can to help you out. And if you have any other questions that you may think of which aren't relevant to the talk today, by all means, get in contact with us. But I'd like to thank you very much for joining us on this morning's webinar. Thank you.